I'm a clinical assistant professor at the University of Michigan, and what we said, go blue. Okay. What we're going to be doing today is talking about how we think about transactional skills in an international context. So it doesn't surprise me that this is a smaller group. This is sort of a subspecialty. But let me just do a very, very quick survey of you. How many of you now in this room are teaching an international course? Anybody here? Sort of. What is it that you're doing?
Well, I teach to international students, and there's inevitably an international.
Okay, terrific. Okay, is it an LLM program at Georgetown?
Actually, I do too. I'm going to be teaching to LLM, foreign LLMs in the fall.
Okay. So we've got two that are actually trying to develop classes that would be aimed at an LLM student, primarily LLM student body. Mm-hmm. Anybody else doing anything? Yes, sir.
We have a Master of Comparable Ops program for non-U.S. students that I direct, and seminar directed for writing their thesis.
Transnational?
I'm sorry?
Is it transnational law?
Comparative.
Comparative.
Okay.
Yeah.
Okay. What is the other interest of those of you who are not doing that here? Why did you come to this room as opposed to some of the others?
Who cares?
Pizza friend of mine.
This is our audience. This is our audience. Go ahead.
Pizza friend of mine, so I want to.
Perfect. Perfect. And even though he's being a little rude, we will get to work. This is work, sir. Yes. What else?
I'm not into the touchy-feely stuff.
Yeah, I'm a clinical professor, so we actually try to get to know our audience. Yeah.
I'm going to do an export business simulation with students in China and students in the U.S. And,
interesting.
But I need to know what you...
And it's a simulation. Fascinating.
They have their own software, the Shanghai Institute of Foreign Trade.
Oh, fascinating. Okay, yeah.
I actually have a fair number of refugee immigrant clients in a wills drafting clinic, and I'm looking at how we can develop, a small business clinic and wondering.
Oh, super. And you're our last.
I just thought it was interesting.
Interesting topic. Super. Okay, so the way we thought we would structure this is we're going to take just a few minutes to explain what each of us here is doing in this space so you understand the frame from which our comments are coming. Then what we thought we would do, so we'll do this for about 10 to 15 minutes. We've each sort of agreed that we're going to keep our talks to 5 just to tell you what we're doing. Then we're going, if there's something as you're hearing us describe what we're doing, if there's some kind of burning question or issue you want to make sure that we talk about, note it on your index card. I'll just come up and grab them from you if there's any, just hold them up. Then we're going to have a dialogue right here, among ourselves, because we've all agreed that we're going to embed in our conversation some of the themes and topics we wanted to talk about. Then we're going to stop in the last 30 minutes, and it's going to become a dialogue with you. So you can frame some of the issues that you want us to have, but when you have your more specific questions, we'll take that in the last 30 minutes. Sound good? Yeah. Terrific. So we have here Kojo Yelpaala, who was telling me that his last name has a wonderful meaning. So why don't you tell them from your Ghanaian history and ancestry?
My grandmother, when I was born, decided that we're at the dawn of a new era. I don't think it was because I was born. But, my last name, Yelpaala, is that Yel means a thought, an idea, a vision, an era, an occasion. Pala means new. So, she said we're at the dawn of a new era. And they sent me off, and that's why I'm here. And, I've been teaching international business transactions for a number of years now. I started out my first class in University of Wisconsin when I was a student. And I was telling you yesterday that the dean didn't know enough to give me the class, and I've been teaching it since then. I came here to this country to figure out how lawyers should deal with business clients and business transactions. I worked for the government of Ghana for a couple of years, and we had very difficult transaction issues. and we often got bad deals. So as a young lawyer, I wrote a memo to the government explaining why it was necessary as a country to protect the interests of the country, to train lawyers working in the Justice Department to be able to negotiate better deals. And I say, if we got a bad deal, it is not because we got cheated, it's because we were unprepared. And that we should stop blaming people for not doing our homework. So I left Ghana and I went to business school. And I got an MBA. And then I went to study economics. And then I studied econometrics. I studied development theory, trade theory. Spent a lot of time in school. And so the approach I take in international business transactions is preparing the students how to understand the mindset of the client. The lawyers are notorious for saying, you can't do this, you can't do that. So I start out by trying to frame the course in terms of the mindset of the client. And the course is not strictly legal. It is not about the law itself. It is about the context of transactions. So I try to develop a deeper understanding of the context of international transactions. So I move on to the strategic mindset of the client. What is the client thinking? And there, successful enterprises, successful business people are visionary. They always see beyond the horizon, and they see the promised land, and it is full of gold. And so they also have this idea that anything that can be imagined can be done. And I'm from a little village. I was a shepherd. I have the same mindset. If I can think about it, it can be done. So the question is, as a lawyer, how do you take your client who has that mindset and take the client to where they want to go? It is like going from point A to point B. Both are suspended in space. It is not a single line. It is not, neither is it linear. So I tell my students, if the way to think strategically is to think flexibly. And the client, I tell them, is disinterested in the negative. Otherwise, they're not coming to you. As long as the objective is lawful, the question is how. And your job as a lawyer is to map out, the how, and to do it in the most effective and legally protective way. So I move on to what distinguishes successful enterprises from those that are not so successful. And what you find is that if you look at Microsoft, if you look at Google, if you look at all of these enterprises, they are good models, even for small startup companies. They have this mindset. They are rule makers. They are not rule takers. They set the pace. They don't wait to receive. They are mostly building industries. They are looking at the vision, and they're looking at where the competition is taking them. They are less concerned about the competitor, because the competitor may be wrong. They are concerned about the competition. What is it that this is all about? What is at stake? And they are architects crafting the future. And hope, not anxiety, is what drives them. So as I tell the students, I said, this is how your client is thinking. Now, you can't go in there and throw cold water on it. Nor should you make the client, impossible for the client to achieve his objectives. So I take one step further, the strategic architecture of an enterprise. What is a strategic architecture? Is the corporate blueprint for what I call intercepting the future. Once you have imagined the future, what steps must you take today to ensure that the future dream can be realized? That's what I call intercepting the future. So this strategic architecture helps you identify what must be done right now, so that the future goals of the client can be achieved. And I use models, I use examples. One of the examples that I use is NEC, a Japanese company. In the 1960s, late 60s, they were seeing about 25 years ahead. They saw that technology, computers, and telephones would be merged. That you will no longer have telephone switching systems, it will all be computerized. So they set out to become the leaders in it, and the question was how. And they had some competencies, but they didn't have others. And so they set out to acquire the competencies they didn't have, and they had to do it carefully, because if the competitors knew what was going on, they wouldn't cooperate. So that is the setup. Now the lawyer. What is the role of the lawyer? First, the legality of the strategic architecture. If it is not lawful, you can't start. You shouldn't start if it is unlawful. Second, given that it's lawful, then you have to design a strategic map of a road that will take the client to that promised land. And I start by telling the students, transaction lawyers, we view the law as not a negative edict. We are not dealing with prohibitions. We are dealing with the law as an enabling factor, the enabling enterprise. The law enables you. Transaction law is about enabling the enterprises to achieve lawful objectives. The law is not an enemy. If you spend your time, if you see it as an enemy, then you have to fight it. The law is a friend. It's a friend that has certain limitations. And you can understand the limitations of the friend. And if you see it from that angle, then it permits you to craft. But most important, the most important thing the students get, and I get emails all the time, is what is on the slide now. The law is nothing but a little dot suspended in space. Period. If you are a good strategist, if you know what you're doing, the law is nothing but a little dot suspended in space. Just think about how many ways you can deal with it. You can go beneath it, you can go around it, you can go above it. If you want to spend your energy, you can drill through it. But why? And once you understand that the universe of the transaction, when it is lawful, that the law cannot prohibit you. It will not going to stop you to do something unlawful. This allows me to introduce the issues of ethics. In the ultimate, a good strategist, a good lawyer who is a good strategist, in the ultimate, the only check is themselves. Because if you don't have a morals checkpoint, you will go over the precipice. And in a way, that is what happened to Enron. Mm-hmm. And I can see why Jeffrey Skilling believed that he was innocent. Because if you know anything about him, and you know about corporate finance, and accounting, you can see why he's defending himself. But I think they reach a point where they should have stopped, and they didn't. So that is where I leave it with the students. There are some other things that I'll talk about, but I will pick that up later.
Thank you very much.
Yes.
So, Peter.
I gave something out to be Xerox. Do we have it?
Yes, people have been taking them as they...
All I was given out is the first day's assignment from my international contracting class.
Is there anyone who doesn't
It's
have
not any big deal. Just give you an idea of what's about. I teach a bunch of different things. I'm first of all, I'm a classroom teacher. I'm not a legal writing teacher or a clinician, but I've taught legal writing, I've taught drafting, and I run a clinic. I also teach contracts and constitutional law. And I've now sort of got a thing where it looks like half, you know, I'll teach common law and contracts this year, as well as run my transactional clinic, which is a small business clinic in Houston. For about 10 years, though, I had a dean named Steve Zamora, who was a very good international finance guy, and Steve was in charge. I think it was before he became dean. I was looking for a new course. I said, well, maybe I'll teach IBT. Never did. I don't do commercial law, so you know, IBT is basically a commercial law course. And he said, how about doing international contracting? I said, what is it? He said, well, it's whatever you make it is. My then wife said to me, who was a lawyer, said to me, what's the difference between international contract and any other contract? I said, I don't know. But what I decided to do with it was turn it into a simulation course. And I had 3 different adjuncts who worked with me at various times. My third guy was the general counsel for an oil service company for a number of years and took them through billions of dollars of mergers. He was merger counsel, he wasn't general counsel. And so we put this thing together. We had about 28 students, typically. I tried to get about a third of them to be foreign LLMs, because I really wanted, rather than people, you know, play acting cultural differences, I wanted to have them there, and it seemed very sensible. It worked fairly well. Sometimes our American students patronized the foreigners, and the foreigners frequently were better. Well, in the old days, it wasn't that way, because we used to take LLMs, you know, law is an undergraduate discipline in most countries, so we'd have people really who were just college graduates. But now we're taking people who are practicing lawyers, and they're very good. And you know, some of them get very annoyed, and I don't blame them. I've told the students off. At any rate, the first day's thing was just that I had them, in this particular thing from 3 years ago, that I just pulled out my papers, and which are now strewn over everything. I gave out for first class the MCC Marble case. That's a case from the 11th Circuit holding that the particular transaction was covered by the CISG, and the CISG has no parole evidence rule. And then the Association of Bar of the City of New York's International Law Committee went to this strange organization of this advisory board that works out of Pace on the CISG, and they wrote an opinion upholding the 11th Circuit, which I'm sure was very happy to hear by these people. But it's a great opinion, and it comes out reading like a restatement with footnotes and everything, and a little dedication to Alan Farnsworth, who had just died. And it's a very strange-looking document. But I gave this out for the first day class, so the students could realize that here's the thing, you know, most American lawyers don't even know what the CISG is, and that it could govern a transaction strictly within the borders of the United States. At any rate, we did that, and then the next 3 days we're using one of Tina's competitors, Thomas Haggard's book, which is skinnier. I switched it to your book in the last year I was doing the thing. But in 3 days, I gave them the drafting to do. That is, basically, I said, you're going to learn how to draft quickly, you know, and then we're going on. I'm not spending the whole term teaching you drafting. You know, my view is, you know, avoid legalese, avoid ambiguity, write the Queen's English and keep it simple, stupid, and that's how you draft. You know, but Mr. Haggard has a little more than that. But after 4 days, we were getting going. We did some amount of substantive stuff, not much. We had no book. We never had a book in the course. One of the problems with it. But we'd have somebody coming in talking about the Foreign Corrupt Practices Act and things like that, and I explained, and my associate dean gave a very good 1-hour talk on letters of credit and things, but basically we got people going and we simulated deals. Now in hindsight, I've concluded, and I'm not teaching the course anymore, my adjunct took it over full time. It was too hard, it was too much work, it was too much work for me. because I was getting 30 and 40-page documents from 7 different teams. Because I'd have, you know, two-person teams typically. Sometimes we got stuck with 3, but typically 2-person teams negotiating a deal. One of our deals that I pulled out involved a telephone franchise in China, a joint venture between an American telephone company and China. Now, it was a completely wrong deal because I completely forgot about cell phones, and nobody is stringing wire any place in the world. But this thing was all about stringing wire in some province of China near Korea. I don't know how we picked it out, but we had a fellow working in our library who's now at St. Mary's, who was Chinese, and he was from there. So he came in and told us about Chinese law and told us about this area right near Korea, in Manchuria, that had been Manchukuo during World War II under the Japanese, and this kind of stuff. It was very useful. At any rate, what I found was wrong was there was just too much work. In hindsight, I would teach it with much shorter assignments, focusing on, you know, some parts of contracts, maybe ending up with them doing one. My basic thought is that most law students have never read a contract from beginning to end. The problem is most contracts, you know, sort of aren't worth reading from beginning to end. Even if they're good, I mean, they're boring. And I still, I mean, I've been working on these things for 10 years, and I still ask, why is it 40 pages long? And think, why is my LLC agreement, operating agreement, 30 pages long? I don't know. But I don't know what to take out because I'm afraid it belongs in there. At any rate, one of the problems we always had was, what do we use for forms? You know, I tell the students, as we would all do, that forms are not bad. It's ridiculous to reinvent the wheel. Your client isn't going to pay you $300 or $400 an hour to learn how to write a contract. Yet most of the forms are bad. Well, the problem now, of course, is that the internet has tens of thousands of forms of any type. And so I get 7 different teams with 7 different forms. Well, I had to read the form and then see what they did with it. I made them eventually bring the form in early, and I limited them. One story I had was that I saw one thing, and it had a very strange, I started, when I was going over the contract, very strange definition. I don't remember what it was, but it was bizarre. It was clearly a typo. I mean, there was no way to read it where it made any sense. So, of course, I wrote on the thing and did that. Then I went to the second one, and I found the same definition. And I found it in 3 or 4 out of 7 contracts. So I came to class, and I said, team number 1, where'd you get your form from? I said, you know, there's nothing wrong with this. This isn't plagiarism, but where'd you get it? Sally got it at her law office. I said, team number 2, do you work in Sally's law office? No. Everybody in Houston was using the same form with the same typo in it, and no one noticed the typo. It was all over town. It was an amazing thing to look at. So these things went on. Well, at any rate, just wanted to make a couple of points. We would give out a detailed story about what was happening, and then we'd give secret instructions to each side. You know, how to cheat the other side and things like this. And, you know, what they could, it really wasn't how to cheat them, but, you know, as much as you can give this, but don't give more than this, you know, and things that were their negotiating strategy. One of the things my partner wanted to do in one of the deals was figure out a way to get away with something. You know, with one company not having to disclose something negative. And I ended up saying, well, I'm not teaching the damn students how to steal. I'm just not going to do it. And we had a great discussion. I mean, he was a very nice guy, but I used to say, we have 2 guys here, Good Harry and Bad Harry. Good Harry is the sweetest guy in the world. Bad Harry is the guy who was working for the years in this web company. You know, and he'll steal your eye teeth. And that was a problem. I also put in stuff about fair labor standards. I did a thing on that when we started looking at it. That was right around the time there were all the scandals about typically clothing manufacturing, Guam and things like that. There was a big case in the 9th Circuit. and stuff along that line. And how do you put that in? How do you do some of the ecological stuff? We did try to put that in. But of course, the main thing is to just have them going and doing negotiating and then drafting. And as I say, the problem was, I think the drafting is just too long and too much. But basically, it was very useful, and students seemed to like it. They seemed to get something out of it. And it was fun, except when I had to, when I'd have the papers, the contracts backing up, and the next one coming out, and I hadn't yet got the last one in, and so forth. But I think there is really something to be done in this. My partner is still doing it. I've also taught it. I taught some Mexican students in Monterrey one year when we were doing a program with the University of Monterrey, and I used one of the problems. And this summer, my school is doing a program for oil lawyers. We're in Houston, so everything's oil here. Oil lawyers from Angola. And I'm to teach them contract drafting and to do it in 28 hours of classes over 7 days, 4 hours a day. Now these people, I presume, English is at least their third language, since they presumably have an indigenous language, and then Portuguese, and then maybe English. I have no idea if it's going to work. Again, I'm using the Haggard book because I just decided I can't overload these people. We're sending it to Africa, telling them to read it before they show up. I have no idea what I'm going to be doing in that course and how I will make it work, because I don't know what my students are. Just one last thing. Some guy got in touch with me. He wanted me to give, me and a couple of other people, to give a talk to Chinese lawyers. Chinese oil, I think they were oil people. I'm pretty sure they were oil people. But anyway, Chinese, they were law professionals, whatever that meant. And I got there, and I said to the man, well, how good is their English? I'd like to know before I give the talk. And he said, they don't speak English. I said, what? He said, we have a simultaneous translator here. I said, you've got simultaneous, you told me 5 minutes before my talk that I'm going to be working with a simultaneous translator? And so I go to the guy, and we shook hands, and I said, I guess I should stop every couple of sentences. He said, no, I'm pretty good at doing it. He turned out to be an American lawyer born in China, who was perfectly fluent, of course, in Chinese, in Mandarin, and also was a first-grade lawyer, and he was actually incredibly good. And he could go with a whole paragraph, and fairly complex ideas, and translate them into Chinese. It was really an amazing experience. Anyway, that's about what I've got.
So, thank you. Can I ask our assistant?
Yes.
So I have handed out, again, index cards to you. If there's some themes that are coming up that you would like us to talk among ourselves, please write it on the index card and just hold your hand up and she will pick it up. I'm going to try to make my presentation 3 minutes because I had promised each of us would do 7. So I've allowed you to eat into my time. So I run an international transactions clinic. It is the first of its kind in the United States. We run real deals that are cross-border with real clients. So this idea of complexity is one I think we might want to tease out a little bit in our broader conversation. I'm out of Ann Arbor, so a question I had when I was setting this clinic up, we're in our 2nd year, was how international could a Midwestern clinic be? Where could we work? Who could we serve, and what could we do? I mean, these are pretty basic questions, right? And the answer is, it could be very international. We've had clients in Russia, France, Bangladesh, Netherlands, Italy, Tajikistan, England. I mean, I can go on. Part of the reason we could do this, we've had deals that have taken place in Africa, Central America, former Soviet Union, and Latin America. Part of the reason we could do this is because the physical infrastructure needs in today's world is very easy and cheap. I tell my colleagues that all I really need is a computer, a telephone, and an alarm clock. And the only technology that failed me was the alarm clock. Exactly. But this is, so if I can do it in Michigan, you can do it anywhere. And so in a way, it's great that the first sort of pilot of this kind of transactional clinic that has cross-border implications started in the Midwest. Who can we serve? Well, this was a very interesting question, and part of it went to what were the teaching goals of this clinic. I have given to Emory for their resource library my student clinic guide. Okay, so if you want to see what I do with my clinic, the whole sort of student manual is there. But you have an excerpt from that, which are our teaching goals. And what was interesting is before I started the clinic, I went around to law firms in New York, because that's where I come from my transactional background, and I interviewed partners there and said, what do you wish the international associates knew, those young lawyers that are coming in to do international deals? And it may not surprise you, although it did surprise me, that they were less interested in the knowledge of the law and much more interested in the softer skills. How do you develop client engagements? How do you communicate with clients? How do you communicate with the other people in the firm? How do you work as teams? So you'll see we actually put our learning goals into 3 buckets. We have a bucket that goes to the legal capabilities and technical skills. We have a bucket for the client relationships, and then we have a bucket for the teamwork and the personal development. It's the 3rd bucket that has been the hardest for my students in the clinic. They don't know how to work well as teams, and I think one of the things I'd love to talk about with this group is when you put students into teams, what are some of the things we do to help those teams work more efficiently? So then we stepped back and said, okay, who could we serve? We needed clients who would be willing to have students do their work for them. I ended up trading on my own name, and I basically sold the clinic by saying, here's a free way to get me. And I promise you that the quality of the work will be such that I would be willing to put my own name on it. Now that put a footnote on that causes a very interesting dynamic with the students. When your need for the quality is so high that you're going to always be the last reviewer and sometimes the one who scraps what the student has done and does it yourself. So there's a workload function in that. We went to the world I had been working in, which is microfinance. So small loans to poor people in developing countries. The first year, 90% of our work came out of that community. This year, 70%. Not because we've done less microfinance, but I've been able to grow the size of the clinic. And there are other types of social enterprises, double bottom line businesses, businesses that are not only trying to address financial return, but are trying to address a global problem. And we are now getting to a point where it's not Deborah Burand's reputation that's selling the clinic. These social entrepreneurs have heard that there are students in Michigan who can deliver high-quality services to double bottom line in companies or investors. And they're coming to us because we have this expertise. So that's been, and that has happened in just a 2-year period, which I think is quite extraordinary. So what kinds of things are we doing? I put things into 3 major items of sort of ways you might be an international deal lawyer. And I did this for a couple of reasons. One of which, I wanted the students to see a broader range of the kinds of ways you are an international transaction attorney, but I also needed to take a little pressure off of them. So the one bucket was live deal work. That puts enormous pressure on the students and on the supervisor, right? Because you've got time sensitivities, you've got complexity. So everybody, we try to get everybody, it doesn't always work, we try to get everybody to exposure to a live deal at some point in their time with us, and I have them for 2 semesters. But then I needed other kinds of things for the students to do. That one would allow slow motion lawyering, because you don't do slow motion lawyering when you're in a live deal. So the other buckets were, 1, enabling environment work. We started working with clients who would want us to help them think through, what are the questions I need to ask my local counsel? So local counsel questionnaires. What are the kinds of things I want to know from desktop review about the enabling environment in a country that would inform what I want to pursue with local counsel? So while we weren't practicing the law of another jurisdiction, they got used to starting to look at other countries' laws. Where would you look for it? What are the main issues you need to focus on that are relevant to your client's needs? So enabling environment work. The third bucket, which is where I've seen the greatest growth in my students, has been in development of documentation. I was able to get the IFC, which is the private sector arm of the World Bank, to have us develop some of their forms of documentation. Now, when you have to develop a form, and you're not just pulling it off the internet, you really have to understand it. I got another client to have us annotate their form of documentation, to describe what the provisions were in plain English, in a way that even a non-English speaker that's not their original language could understand. Most recently, I got a client to hire us to look backwards at deals. So he shipped to us 12 transactions that his company has done and said, I am so focused on getting the next deal closed, but I'm really worried about whether we have been consistently looking at legal risk. Please review these deals and show me where the landmines are. So those are my 3 buckets: live deals, enabling environment, and then documentation development or analysis. So the students touch on each of the 3 of those things. I usually have them working on 2 to 3 things at a time, because the live deal work is just, it's up and down, and tomorrow it's really slow, and the next day it's speed up. I needed it yesterday. So this also allows me to fill in. So that's what I'm doing in my clinic. So again, if there are major themes that you want us to talk about, what we're going to do is we're going to take the next 20, 25 minutes and have a conversation right here. And then we're going to open it up for you to just throw other questions at us. But I thought this way we might be more efficient. But if there are, again, topic areas that you want to make sure that we reach, just put your hand up with an index card and let us know. I've handed these out. So
that way we can read them into the microphone so they can be recorded.
Yeah, we're also trying to make sure that we can communicate.
Can I ask you a question?
Oh, great.
Deborah?
Yeah.
Well, I mean, we need some applause.
Oh, no. So let's go right to our question.
Yeah, how many credits do they get?
So I've shifted around on this one. The first year I gave too little. This year I gave too many. Next year I'm like Goldilocks. I'll get it right. So I am going to give 3 credits for the first semester and 4 for the second. Mm-hmm. And the reason for that is, and so maybe this is to jump into our dialogue. So let me just sort of turn and look at you all as well. A real big question for any of these classes, and I'd love to hear you all respond to this, is how do you build foundational knowledge that's strong enough to support the international overlay to be brought into it? And so what we did, the first year, we just jumped. Held our noses, jumped, and then went, wow, this was hard for all of us. This year, we did a 7-week boot camp. So we actually did not introduce the students until we were 7 weeks into the first semester. Yeah. And we tried to teach to the kinds of matters we knew this client, because all of our clients but one returned after the first year. So I sort of knew now that we do debt, we do equity, we do a credit enhancement. So my first semester is a little less, how can I say, time intensive, because I've got this boot camp in there. It's the second semester when they're running 100 miles an hour trying to meet clients' needs, and that's when we had to boost the credits.
Do they get a grade?
Other learning. First year, I said it was pass-fail. Students came to me the second semester and said, we really would like to have a grade the second semester, and advanced clinics give grades often. So I was naive, and I said, sure, it's a pilot, let's do that. And then I saw inappropriate behavior within the students. Things like, Peter's not doing his job. Mm-hmm. I just want you to know I drafted that. The teamwork I was trying to build dissolved. So I'm trying to keep mine pass-fail.
Yeah.
But how do you feel?
Well, my clinic, remember, right, I'm doing a small business clinic, so it's not like this, except, literally, I expected I was going to get guys doing taco stands in factory parking lots. That's what I expected to get. And that's fair. People try to earn a living. Literally, the first client I took by 4 students. Oh, by the way, how many do you have?
First year was 9, second year was 14, next year will be 16.
How can you possibly handle that many people?
I have help.
Yeah, well, that can
We'll talk about, let's put a
Yeah.
footnote, I want to talk about how do you get help, but let's go on.
I packed we packed into a car and drove down to this company that was selling heavy equipment to Nigeria. This is my first small business clinic. And, and it was rather interesting, and they're relatively sophisticated people. I was telling, and because I had been doing the international thing, I was talking about things like the Incoterms with them and stuff along that line. At any rate, that was funny. We got some guy who's trying to sell surplus medical equipment in Guam or Philippines, and that gets into questions. So we pick these things up, though most of our clinic is more domestic stuff. In my other course, in the international contracting, every term I had some behavioral problem. Somebody who was a problem, either dropped out or never was around because he had a job and it was missing assignments, or somebody who just couldn't get on with the team. Out of 28 people, there'd be one, almost every term. And this was a problem. And the real problem was, I said to them at some point, I said, look, if your partner's pulling you down, or if the other side is pulling you down, it's going to affect your grade. We did pass-fail for a while, and the dean didn't like it, and I wasn't happy because they stopped. They didn't work that hard at the end. But the grading was very difficult to do because we have a curve, and I'd have to give some people lower grades than I would like. But I said to them, look, here's what you do. You have a problem with somebody. First of all, you talk to them about it. You confront them with it. If that doesn't work, you call me up. I'm the boss. And understand, if you're working in a law firm and you're calling the partner all the time on your fellow associate, you're both going to get canned. So it's really up to you to try and work these things out. But I don't want to hear about them the day the papers are due, the day the contracts are due, that we couldn't get it done. We had that happen at least one time, where one side turned in their draft of the contract. The other side never negotiated with it. Things like that.
There's a couple things I want to tease out here, and I'd love to hear, Kojo, your thoughts on this. One of which was, do you have your students do anything in teams, or are they individually working in your class?
Because I've done this for such a long time, I've experimented with every single one of those things. When I started out, I was an oddball at this, at McGeorge. Nobody gave projects. I gave projects in my first year of teaching in groups. What I did was I collected, the student profiles, and then I matched students that I mismatched them. I deliberately mismatched them.
Deliberately.
Yes, so that I had to sort of force them to learn how to work with each other. And then they were doing group projects. And the same issues that Peter's talking about came, because after a while I will get a report. He said, well, this guy didn't do his work. He says there's too much free writing. And so I switched. And I will give a project at the beginning of the semester. And now the students would create a strategic structure and explain to the client why this is good, strategy for the business objectives they have. And then I will grade them, and then we'll have a client discussion. What are the different options? What are different ways in which the client could achieve its objective? And then I'll give them the next project. And I'll grade them again, and we'll have another class discussion. But it turned out that after a while, after the first project, some students got really uptight when they saw the red ink. And I told them, I said, look, there's a learning curve. All of this will wash out at the end. But at the beginning, you're trying to figure out, how do you write an explanation to the senior partner that you're working with?
that this is workable for the client.
Sure.
Yeah, so you need some feedback. And, after, I did that for a while, and then the class changes. After they get the papers back, it got very tense, and so I switched. Again, after some years, I switched. And I'll give them a take-home. I'll give them a 48-hour take-home. 3 projects, 48-hour take-home, and 3 alternatives, and then I'll grade them. And last year, I switched again. Yeah, but dealing with the emotions, and it's a very tough way to teach.
Well, it's interesting. I wanted, because many of you are here because you're teaching with LLMs, and one of the questions that came in is, how do you work with students whose English may not have the same level of competency when that's your working language in the classroom? And here's an example of something that happened with us. I deliberately tried to get LLMs into my clinic because I thought an important part of being an international lawyer is effectively managing local counsel. So if I could get local counsel into the classroom, we'd start to find some of those challenges of what happens. And one of those is language. So what happened in my team playing exercises is the LLM my first year had very, very poor English language skills. Lesson to me, I had brought her in based on her written application. I had not interviewed her. I will never do that again. But so she sort of fooled me about her competency. Clinical teaching and simulation teaching and anything that involves a lot of conversation and not a lot of textbooks, and we're going to go to sources, often means that you have to really have very strong audio as well as an ability to speak. So the students came to me and her team and said, she's not pulling her load. The reason we missed yet another deadline is we asked her to do this part, she didn't do it. And I said, no, we have this conversation as a group. So not unlike what you did, Peter, I put some boundaries. And I said, you would need to have a conversation with all of us, first with her. If you can't work it out, then you bring me in, but it's all of us. It's not tattletale behavior. We ended up talking with her because I didn't want this to become too much of the she is our weak link. And we turned this into Sylvie, you will be going back to your homeland someday, and you will be local counsel, and you'll be dealing with people over the phone often. So how can you develop communication skills that draw on your strength, which is your ability to read and write extremely effectively? So we came up with a strategy that after every meeting of her team, she would write an email to the students saying, I hear this is what you want me to do. And if she got it wrong, they could correct her. And so while that was messy, while there was tension there, I think there was a learning
I think it's a very good idea. I think so. Do you know what kind of TOEFL Michigan asks for?
I don't know.
We have a 600 TOEFL, which is pretty high TOEFL. And I mean, our just attitude is that people don't have English, they shouldn't be in our school. We can't do it. Now, that doesn't solve the problem of oral versus
pretty
writing.
technical and right.
Well, it's oral versus writing, and from some cultures, I think particularly Asian cultures, their written English is excellent, and their oral English is conversational English often is not. And I think the person doesn't have English, and turns out writes beautiful English. And I have found that a lot. And I think that's an answer, that email answer is very good with it.
Another issue, of course, though, is also how clients engage with students whose English language capacities seem to be weaker. And what I found is that the clients, and I had to be very sensitive to this, because I found that clients tended to give more deference to the students who had non-accented English. When they were my American-based clients, but sometimes even my European-based clients. So I had to, at times, literally hold up the student who had a heavier accent to showcase their work and show a lot of deference myself to them. So I would be saying, Kojo, tell me more. Peter, that's great. Kojo, you know, because I wanted to role model that this student had a lot to offer that the students, that the clients sometimes were missing.
See, I have a different, not a problem, but a different angle on this. Most of the students in the class, they have good English skills. And my class over the years draws a certain class of students, people who are looking to step out of the boundaries, people who are willing to be challenged. You know, so my job is to provide them with the background, the economic and business background, which influence the way deals are made. And you know, and I have some slides that are prepared to demonstrate that, because once you have that, then you can structure the deal, and when the deal is properly structured, it is easy to draft the agreement. And but until you have that, yeah, you are just lost in the forest, and the job, you know, for me is to teach both the business analysis, to use transaction cost approach, you know, to look for the vulnerabilities in the deal, to look at points of friction where the deal is likely to fall apart, and how to identify the unspoken, the unstated objectives. You know, just by if you gave me a proposal, I could tell immediately what the other person's goals are, even if they didn't tell me. So my job is to teach the students how to listen, how to see.
Can I go to that? Because that relates to one of these other questions that we got, which is how do you help students understand differing cultural norms and build relationships, not just contracts? And what does one do? Particularly, again, we're talking about what makes us a little different than a domestic transaction. And so what do you do? How do you help a student really hear a client when in fact there's a cultural barrier too?
Well, I have simulations during the year before the finals. You know, one of the things that I gave, the sample exams, you know, that I gave, I had a Professor Epstein from Berkeley, who was, you know, was a friend of the president of Mali, and he went to the desert to work with the Berbers to understand the oasis, and he figured out, you know, how to, you know, he developed what I call a miracle compost.
Is this a real person or is it fictitious?
It's a fictitious person. Yeah.
No, I'm just curious.
Yes, but you know, but I'm you know, and this miracle compost really can transform the desert. But you got a lot of help from the Berbers, and you got some money from the, you know, Food and Agricultural Organization, and the World Health, you know, the World Health Organization. They are not interested in the patent, and you know, so right there, you know, so as a students, how would you put this deal together? You have this professor who was, he was adopted by the Berbers as one of their own. Okay, and now he has a patentable invention that has incredible potential for the environment in the desert. You know, how do you put this deal together? And you know, there are so many parties, so many interests, and you know, so what it compels them to put themselves in Africa, to deal with an American inventor, to deal with the health issues, to deal with trade governments. Yeah, it is. You know, that's how I function.
Let me probe on this, because one of the things and this comes out of sort of conversation I had last night in the cocktail hour, is that a risk of assimilation is that you're pretty clear about what everybody's saying to each other. But that's not how the real world works. And the beauty of my clinic is that my clients are often inarticulate. And so, so we get off the phone from the client, and then we all look at each other and say, well, what did they just ask us to do? And so, trying to be active listeners. How do you address that in a simulation? And with that, he goes to the PowerPoint. Great. Peter, have you had this issue come up?
Well, yeah, not so much, not in the international contracting class, but in the transactional clinic all the time. I try to, first of all, I always go to the first meeting with the students, and I always wave my bar card, making the point you're making, and that my ticket is the one that's online, and therefore everything they do, well, I want them in charge. Nothing's going out that I don't approve because it's going on my bar card. And I usually wave my bar card at the client at that point. And, and the students know that. But we do have that kind of problem where we lose it sometimes. And we have, things that drag on and things like that. And nonprofits.
Okay, let's pull that on.
Well, it seems to me that in a simulation context, things are not clear. Okay, if you have, this is later on, much later on in the course, when I start to talk about joint ventures. And as you know, if you have joint ventures, two parties, they will have some common objective. Let's say it would be to develop a new computer, program. It will be, they may have complementary technology, and they may have, some, some interlocking interest. This is a simple situation where you have a common interest in the middle, but you have competing interests in the outside the middle, and. But what I try to do is, the common objectives, there are some that are stated. There are some unstated objectives. The real reason why the people are going to the joint venture, they are not going to tell you. And then you have your conflicting objectives. And I focus a lot on how do you, from the deal, identify the real reason which is not stated. But the one that is stated to be used as a hook for you to subscribe. And then you have the motives. Some are good, some are mixed, some are mutual, some are unilateral. And but any deal that you put together, you have that. So when you increase the number of parties in a joint venture, you see only in the middle do you have a common interest. And then you have these other overlapping interests between some of the parties, but not all the parties. And you go to, to this one, where it is even worse. So what I do with the students is, when you have this situation, what is the best way to construct the deal in such a way that you isolate problems, you stabilize the transaction. And and here, I rely on the Roman, war strategy. In this one here, the first joint venture is between A and C, and then maybe another joint venture between D and C. So that you have a pyramid of joint ventures. That way you isolate the parties based upon their common interests. So that if there's a problem, they have to fix it themselves. They have to fix it before they deal with the other part, the other side of the joint venture. But this is how I approach it, and so it is not that clear.
But what I like in what you're doing here, and I'm doing something. It's interesting. It's not quite the same, but I think it's got the same objective, which is helping the students to recognize the cultural difference, the unstated comments, and whether you map it in a simulation or whether in a clinic, if you sit down and you say, okay, what did we what do we think is really happening here? We heard this. Are we hearing them well? How can we find, what's a tool we can use to make sure we truly understand the direction that we're being pointed in?
There are books.
Absolutely, there are books, but I think part of this is to get the student to internalize it. So the
Oh, I
beauty of a
agree.
simulation in a clinic
Yes.
is that you can give readings, which we do, intercultural negotiation readings, but then you have them actually either role play it or live it. And
Exactly.
so that's, I see what you're saying. May I switch slightly, because I want to go to another comment that has come up. And Peter, you made reference to this in using practitioners as adjuncts.
Yeah.
And I'd love you to talk a little bit about the strengths and weaknesses of
Yeah, well, I've had one partner, 3 different one partners. A woman who had I think, a one-woman practice in Houston that did international trade, I think, with Mexico for a year. And then a guy I knew who had been general counsel to to the second or third biggest rig company in the world.
Mm-hmm.
You're talking about $1 billion company. You know, the rigs cost $100 million a piece.
Mm-hmm.
Things like this. And he was a very nice guy and very smart. At one point had some exchange rate. He'd been a math major in college, and he put in an exchange rate into a contract that was absolutely intelligible. But but he was very, very good. But then he got, after some point, he decided to go into the Chinese furniture business and opened a gallery and sort of disappeared. And he got me into the third guy, who was a friend of his who we knew, who worked out beautifully. This Harry Lawson, this fellow who had been at big oil service company. The problem, I think, is that there certainly are some adjuncts who have the same kind of mentality as law professors, but most of them don't. They're not integrating, they're not into the, I'm sure some of them who are the kind of senior partner who goes over the drafting with the junior. I was thumbing through these things that I've done, and I'm just, holding them up to show, how they're.
Lots of red ink.
Yeah, I mean, I don't use track changes in Word. I sometimes use it, but I mean, I write all over the thing. And, and I don't write it promiscuously. I mean, if it's good, that's great, but most of the time they're going to learn. First of all, the way you learn to write, any kind of writing, is feedback from the instructor.
Yes.
And then redoing it and so forth. So you got to do that. And I found my partner didn't do it as thoroughly as I did and didn't like the idea of giving out grades, which unfortunately meant that the hardest work of the job, going over the things, was all mine. He's a real nice guy, and he brought in a lot of things that were very useful, but for the most important stuff, he really wasn't there. Now he's doing it now, so I don't know what's going on. But and I've seen some adjuncts who, I've occasionally observed adjuncts who are just, absolutely first rate. But I think that's a problem.
The way I've gotten to go to 16 is I am using adjuncts, so I'm the only full-time person in my clinic. Now that has had an advantage, and then I'll talk about the weakness.
Sure.
The advantage has been is that I can actually take on matters that I myself am not expert in. And so I've got this broader range of people who can say, oh, well, I can take care of that sales contract. I'm a finance lawyer. I can do the cross-border financing, but I haven't done as much in the sales area. I've got one of my adjuncts is very strong in funds and equity. So when we get that kind of work, she comes in. We've also had the law firms of these people backing us up. So when we had a tax issue, when we needed an English law, we were able to reach into that. Now, so that was all empowering and broadening the breadth and scope of what we can do. The weaker side of this goes to your point, which is often the supervising attorneys that I brought in, they know how to practice law, but they don't know how to teach students to learn how to practice law. And I actually am still growing that way because I'm a practicing practitioner as well. And I've realized I have to invest in my adjuncts. So it's an extra burden. I get them, but then I've got to spend a lot of time saying, this is not just an associate in your law firm. you've got to take a different approach. And they often, it's hard because they start treating them like that. The other side, so let's take it from the other side. So I asked the students, what was the difference between the adjuncts and the full-time faculty, without it being too much about me versus Carl, say. And one of the things that I saw happening, which we then also had to correct for, was that the students quit looking at the client as the real client. The client became that partner in the law firm who was reviewing their work and not the client. With me, they still kept an eye on who the true client was. So we had to get in front of that and keep pushing the client in front in order to avoid that. But so I think it's a mixed bag.
When I was in law school, my dad came to something and asked Alan Farnsworth why he became a law professor. I cringed as a corner. And Alan said, because when I was in practice, I didn't have time to think about things, to think about problems. And I've seen that, you know, when I was in practice a long time ago, when we were going to bring in a young kid who just, you know, finished his 6 months in the Army, this puts it way back, and had finished law school and so forth. And the partner said to me, let's start him in the managing clerk's office. Give him a month there. Let him read the New York Law Journal. We'll start him slowly. By that afternoon, we had an order to show cause. And, you know, my friend was working on the order to show cause. You just can't do that in law firms, and you don't have the time. You can't afford it. And as a result, that's why there are no teachers. Now, there are some great lawyer teachers, but man, if you charge a client $500 an hour, you can't charge it for correcting, you know, second-year associates drafting. You can do it on your own time, and that's very nice, but these guys don't have any time.
I'm mindful that I said you got 20 minutes to ask questions. I've got more, so if you're quiet and shy, I can keep going. But why don't we also invite from you? So just please raise your hand or just shout something out if there's a question. I know I've got one that I haven't answered that came in, so I'll make sure I get it.
I just want to remind you guys that we're recording the session. So if you have a question, we'd like you to state your name and where you're from and then ask the question. And then we would like the speakers to...
Maybe move that mic over there and people could come up to the mic and actually get recorded.
Yeah, we can do that.
I'm seeing some facial expressions that say they're not sure they want to go.
Oh, well, that's okay. Yeah, whatever you want
it
to
takes
do.
to get a conversation.
Whatever you want to do. I was just at something where people were repeating stuff from the audience. It was just a waste of time.
One of the questions, while I'm waiting, one of the questions that came up went to, and it actually has to do with something you said at the beginning, and I think, Kojo, in a way you have alluded to it, but maybe we can take it on directly, which is dealing with complexity. These are, you know, we're taking on, by definition, because it's international, we're taking on varying jurisdictions, varying cultural norms, varying legal systems, varying objectives. How do we, and you actually said it got too hard, it got too complex for the students. How do we manage that?
Well, I think that's a very serious problem, and I add another problem to it, which is I don't know very much. You know, I don't do international deals. I don't come from 10 years of doing it in practice. I don't do oil deals. And I do these things and I say, I don't know what the hell I'm doing here. I can write a contract, but past the drafting stage, you got to know substance. You got to know about a business, and you got to know about the law of the business. The law of oil and gas is obviously different from the oil of electronics, the law of electronics. And I once had a thing for a dentist where I did a lease, and afterwards he said, my landlord, I didn't do the lease, but I gave it to the lease people. My landlord charged me $1,500 for a heavy-duty cable because I needed it for my drills. I didn't know we needed a heavy-duty cable, but I should have somehow, I learned to ask global questions like that. You got to know your client's business, but you also have to know the substance of the thing, which, as you say, know certain aspects and not others. There's one other point that I've heard about, back somewhat to the adjuncts. A lot of big law firms, now I'm in Houston, so we've got big law firms, are retiring partners at 65. I think there's some tax reason for it, as I understand it. And they're having to do pro bono stuff. And it's been suggested we could use them in our transactional clinic Because these guys could do that in their sleep, and they could take on 2 students, 3 students. So instead of my limit being 4 if I have another course, or 8 if I don't, and 8 is too many, I've decided, because it's like 30 clients, you know, give them 3 or 4 apiece. But I could bring in some adjuncts that way, and I'm just thinking that in other areas, you know, you might get that, and some of those people aren't interested in retiring, they're really interested in working hard, and it could be, you know, a kickstart for them, and they could enjoy it.
So what I hear you talking about is how you manage complexity at the faculty level, but you've been taking, by definition, very complex deals to the students. How do you help the students deal with complexity?
Do you mind if I show you?
This would not rigged.
Why not?
But it works.
It's complex.
Yeah, that's good.
Now, about this second or third week of class, this is where the students are at. Now, if you align the multilateral enterprise as a technique for teaching, because the multinational is a very complex entity, but it also has all kinds of issues coming out of it. And if you look at just the reason for the multinational enterprise, the reason why we have multinational enterprises is essentially the failure of the law of contract. If you could license your technology to somebody in Mexico, and the licensee will pay you the royalties that you deserve, and you will have an easy way of negotiating that licensing agreement, you wouldn't need a subsidiary. But because the information markets are imperfect, and you have your Arrow's paradox, so you need instead of using a licensing, you establish a wholly owned subsidiary, because then it is under your control, and because the subsidiary is under your control, it is also an instrument for transfer pricing. So when you look at the system here, it is internally consistent. It creates its own internal market for shuttling resources within the system that creates value in the tax haven. So the tax haven subsidiaries are these days are described as finance corporations. So so when you look at this, there are so many things that are going on. Some of it is tax driven, some of it is limited liability, some of it is the problem of the failure of the law of contract. Some of it is the flexibility that you need as a group of enterprises. This gives you tremendous flexibility. If you've got 2 manufacturing subsidiaries, you can play with the government. When the government tries to play a game with you, you close that subsidiary. You reduce the workforce.
Kojo, I want to go to the tool you're using, because I think we're gathering the substance.
Yeah.
So what I see you saying here is that one of the things that you're doing very early on in your semesters, you're teaching the students to diagram the complexity. Is that where you're headed?
Exactly, and to see what is going on, to see what, each line represents something. It's a transaction. So the transaction between one subsidiary and the other introduces transfer pricing.
So you're making them follow the money.
Yes.
You're making them identify all the different parties.
Yes.
And then you're helping them to start to understand what the issues are between those.
Precisely.
Yeah, I knew that we got this right one day when I walked into my clinic. We have a clinic workroom, and we have a big whiteboard. And clearly some students had been in there because they had diagrammed a deal. And I was in heaven. I thought, my word, I'm not sure they got it right, but they were trying. Yeah. So, which is something a practicing attorney always does. But I like the fact that you're introducing that concept so early.
My partner, second partner, the guy from the oil rigs, showed us a deal that he'd done in Mexico. And one problem is you can't do those things in Mexico because you have to have a Mexican company doing it.
Yes.
You can't just put your company down there. The Mexicans don't let you do that. And it got very complex where it was like, I said, wait a minute, you got this one giving money to this one, giving money to this one. They're just passing money down. They're not doing anything. And it was all a complex thing, and it involved, under certain circumstances, the company would lend money if they couldn't pay it. Then they realized because differing interest rates,
Yes.
the American company was bankrolling the people in Mexico because the rates were so much lower. They just could turn to the Americans and get it at much better rates. This back in the 70s when the rates were very high. But all these things got incredibly complex, and sometimes people got really burned on them, and that's certainly a very useful
to get into the discipline of diagramming and following the money. I want to go to another, I'm sorry, please go ahead. So I've got two here. Okay, go ahead.
Yeah, right, we got two live ones.
Okay. I'm Jane Scott, and I'm from St. John's University School of Law in Queens. I am just wondering if students who take your courses in international transactions don't ever end up doing international work for whatever reason, despite their obvious interest in it, what do they gain from the clinic? I guess I should ask it a different way. I would think that everything they learn through the clinic would still be applicable to a domestic practice.
It should be.
Right. So what would they get from it?
In addition, that's international. It goes back to Peter's question, which is what makes international different. And I think we've started to tease some of this out in our conversation. There's the intercultural overlay that may or may not be. Could be in a domestic transaction, but not necessarily. There's the different legal jurisdictions, which are not just a matter of another common law jurisdiction. It's New York or Delaware. It's the New York law and perhaps a civil law country.
It's the New York and Louisiana.
It's a New York, Louisiana deal, that's right. But it's also starting to figure out which law applies to which part of the deal and trying to think that through. There is the local counsel aspect of really you're only as good as your local counsel and managing that. So of course there's remedies and then the risk can be quite different. So we have different risk mitigants. We do a lot on political risk insurance and offshore vehicles where you're trying to limit risk. So there's quite a bit that comes on top of that.
Yeah, I'd also point out that just in practical terms, an international deal involves distance. So shipping becomes a big thing, the Incoterms and stuff like that. It involves foreign exchange. It involves language. There are three just practical differences right there without even getting into the subtle.
And the risk of not having another jurisdiction respect the enforceability of the contract really comes up strong. And so if you're trying to contract in a place where you don't really know the rules, that also shapes how people work. Does that give you a flavor?
It does. But what I'm struck by is how useful these courses would be in teaching the kinds of skills that you've outlined, Deborah, for any future lawyer.
Absolutely. I think it is, but I do think there's an additional overlay. Now, I will tell you this. I'm sorry, Kojo, go ahead.
One of the first points I make in the first day of class is that to be a successful international strategist as a lawyer, the most essential subject is civil procedure, period.
Make a good guess.
I said, your job is to make your client invisible in any jurisdiction, lawfully. If you can't be sued, there's no substantive liability. And therefore, let them chase you. And I said, but you need civil procedure. You need to understand your civil procedure. So, all these things, the diagram that I showed you there, there's a lot of civil procedure work going on there. The subsidiaries are not put there at random.
Yeah, also in national arbitration.
That's right. Yeah, so that is where I start. So it works out that way.
It's fairly easy to work with Anglophone former British colonies, because almost everybody's willing to litigate in London.
Yes.
Everybody trusts the British courts and they trust the British, arbitration system. And the Pakistanis don't want to go to Texas. My God, they've all heard about Texaco Pennzoil. And I'm in Harris County, Texas, so. But, everybody will go to London, but that doesn't do you any good if you're, if it's an Asian company.
I think we had another question.
Sam Jackson, Georgetown. Well, what I'm curious about is the value of teamwork beyond just having fewer papers to grade, as Peter was saying. And to what extent is the students' analysis of their teamwork sufficiently self-conscious so that there may be some allocation of responsibility based on their skills, whether it's language skills or otherwise? And to what extent do they sort of draw back and begin to appreciate the value of the team by the way you assess their work, rather than trying to make each one of them masters of every aspect of the...
So I'm going to try to repeat this for the recording, which is going back to the fact that we all often are working in teams with the students, and how do you help the students think about strengths and weaknesses within the team, work those strengths into the way they function, and give them the kind of feedback that allows them to have role allocation. I think it's easier to do in a clinic because it's necessary. So I had students who had limitations on the amount of time they could give a transaction because of they were running off for a job interview, or they were having a baby, or they were, and so right up front, before we end our meetings, we say, okay, who's going to do what? Who can carry the ball forward this week? And they start, the first couple of assignments are really messy, but I noticed enormous improvement. Now, I do in my evaluations, I have the students not give peer review to each other, but I do have them give me feedback generically about how well they thought teams worked, with the idea of using that information to try and to embed more teamwork skill building earlier in my boot camp. That was my first big criticism I got from the students, which is, you focus so much on the substantive law, please teach us how to work as a team early in the semester, and then we'll be able to hit the ground running faster. But I
was just thinking about this thing myself, because I got out my grade sheet from one of these things where I actually was grading each team, and generally together. But at some points, I finally ended up where I had the, let me start. First thing I learned on Wall Street, we got a form and a little handbook, and the partner wrote it, said the first thing to know is when you're negotiating with somebody else, always volunteer to do the drafting. And that's, of course, what almost every decent deal lawyer knows. You always do it yourself. Well, the obvious course is the other guy read the book too, and it's like getting the yes. Everybody wants sunlight in the other guy's eyes. So the answer was split it up, and that's what I told them to do. And I would get it with it. I'd make them tell me who drafted which part of which deal, and which team carried the ball. But I said, but all four of you are responsible for the final product. So it's in your interest to work with that person, not knock them down, but help make it better. I'm still going to know who started it, but I'll also, if it comes out lousy, basically I'm thinking the other three of you failed in your job, which was to make it better. So it was a combination of that. That's very hard to do, especially when you have grades dependent on it.
This is why the grade issue.
It's somewhat artificial, but the good ones, I may have focused too much on the bad ones. The good ones, I think, worked very well together, and they enjoyed helping each other and trying to do it, and that's a wonderful skill to build up.
Okay, I'm aware of the time, so let's do one fast question, and then I also did not answer one of the questions that came to me, so I'm willing to answer that to that person offline, but go ahead.
Related to this discussion and your conversation about grading earlier, have you considered giving a grade to the team, at least on some components of that? Because that would seem...
The problem there, of course, was that somebody works hard and the other person doesn't, that person gets pulled down. Yeah. Basically, that was where I started, but then I started fragmenting it because, when I felt that I couldn't do it right that way. It depended.
I have a built-in motivator, which is a live client. I have not found the grades are necessary for those students to be motivated. So that's why pass-fail works for me. But in a simulation, you get the last word.
You know, when I started, I had much difficulty with this because nobody was doing this, and I was the only one. And I had a fight with the dean about grades. Because if you have a team that produces an excellent paper, even if one of them was a free rider, that free rider got an A. Okay, so it's just through the care up. And the team wasn't really happy about that. And I said, well, but you know, if you know, there's a technique that may over reward some people, may under reward others, and but later I had to to move away from it. Part of it because I couldn't figure out how to deal with this free riding problem.
I also shift my teams. So you may be a team for one deal, and then I'll move you over, and I'll make you be on this team, and then I watch the dynamics so that I can understand what's situational and what might be more reflective of the person.
I taught the course one time at night, and I had some LLMs who were American LLMs. And one of them was a partner in a big firm in Houston. He's getting an LLM, and he came up to me and said, look, all I need is a C in this course to get the degree. I don't need anything better than that. I said, well, the guy was in the oil business. You know, he knew all this stuff. Whoever got on his team got an A.
Yes.
And the guy couldn't write anything that wasn't an A. He was a first-rate partner, and everything he wrote was an A. And whoever got lucky to be on his team got a boosting grade.
Okay, I'm going to let my colleagues say one sentence each, if you like, if you want to grab any last words that you'd like, Kojo.
You know, that I told Tina that I had a proposal for the group, you know, for this conference, and you know, and let me get to it. I'm back to this. I'm sorry, but I have.
That's okay.
We started a little late, so we're still.
I think we're going into lunch.
Yeah.
Transactional education, what's next? What must transactional educators do to intercept the future? Frame it in the context of how I started. Should we, as a group, seek affirmation? And the answer should be yes. Should we seek validation? And maybe yes. But given where I come from a little village, you know, we should take our own destiny in our own hands. In other words, we must do the things that would, you know, so that we can't, the group, you know, this whole process cannot be ignored. And how do we do that? I say that, you know, maybe we should start an annual transactional competition